Workforce Advisory Dean Cameron. Today we're looking at a recent article involving the Fair Work Commission and an employee who had been there just under 12 months in regards to an application for unfair dismissal. The Fair Work Commission has ruled that an employee who was terminated 2 hours before the expiration of the minimum 12-month period for employment under a small business cannot sue an unfair dismissal claim. The decision was made notwithstanding that the employee received a week's pay in lieu of notice. The Small Business Fair Dismissal Code, which came into effect in July 2009, applies to small businesses, operations with fewer than 15 employees, including casual employees engaged on a regular systematic basis. Employees of small businesses cannot claim unfair dismissal in the first 12 months of their employment. The case involved a worker who was employed with a commencement date of the 2nd of March 2020. He was dismissed on the 1st of March 2021 at 1:45 p.m. with immediate effect. At the hearing, the employer claimed that the worker was home at 2:29 p.m. and that his payslip reflected that he did not work a full 7.6 hours workday, but rather only 6 hours of work on the 1st of March 2021. Consequently, the employer contended that the applicant could not make a claim for unfair dismissal as he had fallen short of the 12-month employment period. In determining eligibility to pursue the claim, Deputy President Lake commented that the minimum period of employment must be completed immediately before the beginning of the 2nd of March 2021, which is immediately before the beginning of the corresponding day of the 12th of March, following the date on which the applicant's employment commenced. Pursuant to Section 390 of the Fair Work Act, the Commission can only order an unfair dismissal remedy if the worker is a person protected from unfair dismissal. The person must have completed the period of employment that is at least the minimum period of employment if the employment is the small business employer, if the employer is the small business employer. That period is 1 year, ending at the time when the person is given notice of dismissal, or immediately before dismissal, whichever is earlier. All parties agreed that the employer was a small business employer as defined. The worker accepted that he went home at least half an hour early, but maintained that was irrelevant because he had been sent home as opposed to elected to leave. The employment was covered. Further, he claimed that he was paid 1 week in lieu of notice. His employment period was extended until the 8th of March 2021. On that basis, he submitted that he was past the minimum period of employment and therefore is entitled to make his claim under the Fair Work Act for unfair dismissal. While expressing some sympathy for the worker's situation, Commissioner Lake determined that he could not pursue his claim as he commented, I am satisfied that the difference between the date of the applicant's commenced employment with the respondent, the 2nd of March 2020, and the date he was notified of his dismissal, the 1st of March 2021, is 364 days. the approximately 6 hours, noting turn on whether the applicant was paid 1 week's pay in lieu of notice, because it was just that, payment in lieu of notice, and the applicant would, if the applicant had worked out the notice period, he would have met the minimum statutory requirements. Consequently, the Commissioner Lake concluded that the application had not completed the minimum period, and the application was dismissed. If you have questions regarding unfair dismissal or the Small Business Code, please don't hesitate to contact Workforce Advisory. Thank you.